What if you did everything right, filed every form, paid every fee, waited patiently for months, and then the government just froze your case with no explanation? No denial, no approval, just silence. Sighs. Would you know what to do next? Right now, as you are watching this video, there are tens of thousands of immigrants, green card applicants, and even U.S. citizens whose immigration cases have been put on hold. Not because they made a mistake, not because they are unqualified, but because of where they were born. Let me ask you a question that might surprise you. Curious, did you know that even if you are a U.S. citizen filing for your spouse, USCIS can pause your case simply because you were born in one of 39 specific countries? Not your spouse. You, the American citizen. Does that sound fair to you? And here is something else most people do not realize. There are actually two separate pauses happening at the same time right now. One is a USCIS adjudication pause affecting 39 countries. The other is a State Department immigrant visa pause affecting 75 countries. These are two different agencies, two different lists, and two different consequences for your case. And most applicants I talk to have no idea which one applies to them, or whether both do. Now let me ask you this. If you are waiting on a green card right now and you have not heard anything from USCIS in months, do you know whether your case is stuck because of one of these pauses or because of a problem with your actual application? Because the answer to that question determines your entire strategy. It determines whether you wait, whether you refile, whether you file a lawsuit, or whether you do something else entirely. But before you panic, before you assume the worst, I want to share something with you that I think you genuinely need to hear right now. Because in the middle of all these pauses, all these policy changes, and all these scary headlines, there is a green card approval story that happened just weeks ago that proves the system is still working. A woman who overstayed her visa by more than a decade, who had no special circumstances, no extraordinary case, applied for her green card and received it in just 3 months. 3 months. In 2025. Under this administration. How is that possible? What made her case different? What did she do right that so many others get wrong? I am going to break down every detail of that case in this video because what she did right is a blueprint that could apply to your situation too. But first, I need to walk you through what is actually happening right now with U.S. immigration policy, because the landscape has shifted dramatically and the information you are operating on from even a few months ago may already be outdated. Are you ready? Let us get into it. Here is what you need to understand about the current state of U.S. immigration. On the surface, things might appear to have calmed down. ICE activity in communities has decreased compared to a few months ago. You are seeing fewer dramatic enforcement actions in the news. But do not let that fool you. Behind the scenes, USCIS is being more aggressive than ever with how it processes, pauses, and scrutinizes applications. Let me break down the 3 biggest policy developments affecting visa holders and green card applicants right now. The first is the 39-country USCIS adjudication pause. If you are from one of these 39 countries, or if your U.S. citizen petitioner was born in one of these countries, USCIS has paused the processing of your application. You could have a perfect case. You could have already completed your interview. You could have submitted every document. It does not matter. Your case is sitting in a holding pattern. This applies to adjustment of status cases, family petitions, and more. And here's the part that catches people off guard. It is not just the immigrant who has to be from one of these countries. If the U.S. citizen who filed for you was born in one of these 39 countries, the pause applies to your case too. Many U.S. citizens have been turned away at their own green card interviews because of this policy. The second major development is the 75-country immigrant visa pause at the State Department. This is a separate action affecting a different and larger list of countries. Under this pause, U.S. embassies and consulates are not issuing immigrant visas for nationals of these 75 countries. So even if your I-130 family petition is approved, even if your case has been fully processed at the National Visa Center, the embassy will not issue the visa. Your case hits a wall at the final step. The third development is the expansion of government data access. The Department of Homeland Security is now seeking access to databases managed by the Department of Health and Human Services, specifically the Federal Parent Locator Service and the National Directory of New Hires. These databases contain employment information and child support payment records for millions of people. This is in addition to DHS already having tapped into IRS data and Social Security Administration records. What this means for immigrants is that the government is building a much broader picture of who is in the country, where they work, and what their financial situation looks like. This raises serious privacy concerns and could affect immigration enforcement in ways we have not seen before. Now, there is one more thing I want to mention. There is a new family detention facility being planned at the Alexandria International Airport in Louisiana. This short-term facility is being designed to hold families, primarily women and children, for 3 to 5 days in converted military structures near a runway used for deportation flights. Officials say this facility will be used for individuals who agree to voluntary departure, but advocates are concerned that difficult detention conditions are being used to pressure people into signing departure paperwork. If any of these developments affect you or someone you care about, keep watching. I am going to tell you exactly what your options are. Now let me share the story I promised you, because it is proof that despite everything I just described, the immigration system is still producing approvals. Even now, here are the facts. A Jamaican national entered the United States lawfully in 2013 on a visitor visa. This is important, and I want you to pay close attention to this detail. The visa was issued in her name, and she was admitted lawfully. She later overstayed her visa. She had no criminal record and no prior arrests. She was unmarried. Her daughter had previously obtained a green card through her own marriage. A few years later, the daughter became a naturalized U.S. citizen. As soon as the daughter received her naturalization certificate in 2025, she was ready to file for her mother. Here's what they did. They filed the I-130 family petition and the I-485 adjustment of status application at the same time. This is called concurrent filing, and it is available when the beneficiary entered the United States lawfully and has an immediate relative, in this case a U.S. citizen daughter, petitioning for them. The case was filed in November. The green card was approved in February, 3 months from filing to approval. Now, why did this work so smoothly? Let me highlight the key factors. First, she entered the U.S. lawfully. That is the single most important detail. Lawful entry is what made her eligible to adjust status inside the United States rather than having to leave the country and process through a U.S. embassy abroad. Second, her petitioner was a U.S. citizen immediate relative, her daughter. Immediate relative cases are not subject to visa bulletin wait times. There is no line. Third, the case was clean. No criminal history. No prior immigration violations beyond the overstay. No fraud. No complications. Fourth, the application itself was thorough and error-free. In this environment, where USCIS is scrutinizing every detail, a clean and well-prepared application makes a significant difference in processing speed. So what does this mean for you? If you are eligible, if you have a pathway available to you, the system can still work in your favor. But you have to know whether you qualify, and your application has to be airtight. No guesswork. No missing documents. No errors. Now let me walk you through a few common scenarios so you can understand where you might stand. Let me address some of the most common situations that people are dealing with right now. Scenario 1. You entered the U.S. without inspection, meaning you crossed the border without going through an official port of entry, and you have since married a U.S. citizen. Can you get a green card? The short answer is your spouse can start the process by filing the I-130. But because you did not enter lawfully, you cannot adjust status inside the United States through the standard process. You would need to obtain an approved I-601A waiver for your unlawful presence, and then complete your case through consular processing at a U.S. embassy in your home country. The one exception is if your spouse or another qualifying family member has served in the U.S. military, in which case you may qualify for military parole in place, which could allow you to adjust status domestically. Scenario 2. You overstayed your visa, but you entered lawfully and now have a U.S. citizen spouse, parent, or child over 21 who wants to file for you. In many cases, you can still adjust status inside the United States, just like the Jamaican client in our success story. The key is that you entered with a valid visa and were inspected and admitted. Your overstay does not automatically disqualify you from adjustment of status if you have an immediate relative petition from a U.S. citizen. Scenario 3. You have a pending case and you are from one of the 39 paused countries, or your petitioner was born in one of those countries. Your case may be on hold through no fault of your own. Your options include waiting for the pause to be lifted or pursuing legal action. Group lawsuits are being filed to challenge these pauses, and individual legal challenges are also an option. Scenario 4. You have a work permit, but you are worried about enforcement. A work permit authorizes you to work, but it does not provide protection from deportation by itself. Traditionally, the government has left people with pending applications and valid work permits alone unless they had serious criminal issues. However, under the current administration, enforcement has expanded, and individuals with work permits and pending cases have been detained. If you are in this situation, having a legal strategy and an attorney on record is more important than it has ever been. Scenario 5. You are a green card holder wondering about naturalization. If you received your green card through marriage and you are still in a valid marriage, you can apply for citizenship at the 2-year and 9-month mark of your residency. If you obtained your green card through another pathway, the standard timeline is 4 years and 9 months, allowing you to file at the 5-year mark. If you have a pending I-751 removal of conditions case and you are in the extension period waiting for your 10-year green card, you can still pursue naturalization if you have met the residency time requirement. Do not wait for the 10-year card to arrive before applying. So here's what I want you to take away from this video. The immigration system is under pressure right now. Policies are shifting, processing is slower for some case types, and enforcement priorities have changed. But the system is still functioning. Approvals are still happening. Green cards are still being issued. Citizenship interviews are still taking place. The question is not whether the system works. The question is whether you are positioned to succeed within it. Here is your action plan. First, know your eligibility. Understand whether you qualify for the process you want to pursue and which pathway is available to you based on how you entered the country, your current status, and who your petitioner is. Second, know your risks. Understand whether the 39-country adjudication pause or the 75-country visa pause affects your case. Understand what enforcement risks exist in your situation. Do not operate on assumptions. Third, prepare a clean application. In this environment, errors and missing documents lead to delays, denials, and complications that are much harder to fix than they used to be. Every detail matters. Fourth, have a legal strategy. Whether you are filing a new case, waiting on a pending case, preparing for an interview, or responding to a denial, have a plan. Do not wait until a problem becomes a crisis. If this video helped you understand where you stand, subscribe to US Visa and Green Card info and turn on notifications. I break down every major immigration policy change, every new development, and every strategy you need to know about so that you are never caught off guard. Share this video right now with someone who is waiting on a case, someone who is worried about their status, someone who needs to hear that the system still works. Because the right information at the right time can change the outcome of an immigration case entirely. Thank you for watching. I will see you in the next one. Stay informed, stay prepared, and remember, the system still works.